If you have any assets in Sweden, you probably think you know what happens to them when you're gone. But what if I told you the law's default plan could actually force your surviving spouse to sell the family home? Yeah, today we're going to dig into the surprising truths of Swedish inheritance law. So what really happens to your wealth in Sweden when you die? This isn't just some dry legal question. It's a deeply personal one, and it affects the people you care about the most. So today, let's cut through all the common assumptions and get to the facts, which are, frankly, pretty surprising. Okay, here it is. This is the single biggest misconception out there. Most people believe, quite simply, that if you're married, your spouse gets everything automatically. But the reality, well, it can be shockingly different. Depending on your family situation, your kids might have an immediate legal claim to their inheritance, and that claim can create some huge financial problems for the very person you wanted to protect. To really get this, we first have to look at what the law does by default. What happens when you don't have a will, or a testamente, as it's called in Swedish, in place? And this is where things can get very, very unexpected. Let's make this real. Imagine a family. We'll just call them the Svenssons. So the husband has 2 kids with his current wife, but he also has a son from a previous marriage. In Swedish law, these children from outside the current marriage have a special name. They're called särkullbarn. And believe me, that one little word, it changes everything. So let's say the husband dies without a will. The surviving wife doesn't just inherit the whole estate. Nope. That son from the previous marriage, the särkullbarn, he has the legal right to claim his full 1/3 share of the inheritance immediately. He has absolutely no legal duty to wait until his stepmother passes away. And here's the devastating real-world consequence of that rule. If most of the family's money is tied up in their home, the surviving spouse might actually be forced to sell the house she's lived in for decades just to find the cash to pay out that one child's claim. It is a heartbreaking outcome that most people never, ever see coming. And the crazy part is, it's completely avoidable. So why? Why does this happen? Well, it's all because of a fundamental concept in Swedish law. It's an unbreakable rule that protects your children, and it's something you simply cannot get around. The key term you absolutely have to understand is lägglott. Think of it as a reserved portion. It's a legally protected minimum share of your estate that belongs to your direct heirs, your children. And here's the crucial part. It cannot be taken away from them, not even with a will. So how much is this protected share? It's exactly half of what their normal inheritance share would have been. So let's say a child was in line to inherit 2 million kroner. Their lägglott is a guaranteed 1 million of that. The other million is what's considered your free portion, and you can give that to whomever you wish. And this leads us to an absolute certainty in Swedish law. Unlike in many other countries, you simply cannot write your children out of your will entirely. Their right to this minimum share is locked in, protected by law. It is the unbreakable rule at the very core of the entire system. Now, I know this might sound really restrictive, but it doesn't mean you have no power. Actually, it's the opposite. A will, a testamentary, is your single most important tool for taking back control and making sure your wishes are respected, at least within the bounds of the law. This right here shows the critical balance you have to understand. A will is incredibly powerful. It lets you direct all of your free assets, that portion that's not protected by lägglott. It can absolutely protect your surviving spouse, making sure they can stay in the home, and it can prevent a lot of family conflict. But it has clear limits. A will cannot eliminate a child's right to claim their lägglott, and it can't stop them from demanding it within 6 months after you pass away. Okay, so if the situation for married couples is surprising, the situation for unmarried partners who live together, what's known as sambo, it's downright dangerous. And this is a critical warning for a huge number of people in Sweden. The risk is laid bare right here. As we've seen, a married spouse has automatic inheritance rights. But if you're cohabiting, a sambo, and you die without a will, your partner gets 0. I'm going to say that again because it's so important. Absolutely nothing. Your children or your parents or even your siblings would inherit everything before your partner gets a single krona. It's a blunt question, but you have to ask yourself. If you're not married, without a specific will that names your sambo, the law offers them no financial protection at all. It's a trap that can leave the person you've built a life with completely and totally vulnerable. All right, to round all this out, let's quickly touch on 2 final crucial details: taxes and the most common mistakes that people make. So let's start with the good news. Sweden got rid of its inheritance tax way back in 2005, so your heirs won't pay tax just for receiving the assets. But here's the catch, the reality of it. No inheritance tax does not mean tax-free wealth. When your heirs eventually sell an asset they inherited, like a house or stocks, they will have to pay capital gains tax on the profit. All of these complexities lead people to make a few common and very costly mistakes. The biggest one? Having no will at all. Right behind that is just assuming that living together as a sambo gives you some kind of protection. People also frequently just ignore the rights of children from previous relationships, or they believe a will from another country will work without any issues, and they totally fail to plan for the conflicts that all these surprises can cause. If you take just one thing away from our explainer today, let it be this. The law has a default plan, and it's designed with a specific idea of protecting family. But that default plan, well, it may look nothing like what you actually want for your loved ones. Ultimately, it all comes down to something this simple. Creating a plan, specifically a valid Swedish testamente, is what gives you control. It's what allows you to navigate the rules, protect the people you want to protect, and make sure your legacy is exactly what you intended to be. And that really leaves us with one final question for you to think about. Looking at the reality of the law, not the assumptions, does the plan you have in place right now, or maybe the lack of one, truly reflect your wishes?